Good morning, Mr. Wolffe.
Good morning.
Before your evidence begins, may I remind you that the terms of reference of the inquiry exclude the prosecutorial decision and review. At the beginning of this hearing, I set out my interpretation of how the inquiry should approach that exclusion. The inquiry will not examine your prosecutorial decision and reasoning. The prosecutorial decision and reasoning of Crown Counsel and the recommendations and advice given by the Procurator Fiscal in reporting the case to Crown Counsel. In addition, the inquiry will not examine in detail which particular potential crimes you, Crown Counsel, and members of the Crown Office and Procurator Fiscal Service considered could be relevant. Subject to these exclusions, the inquiry will examine the post-incident management process and investigation conducted by the Crown. As the vehicle for the Crown's investigation was a criminal precognition, that examination will include the work carried out in preparation of the precognition. So perhaps you could bear that approach in mind as you give your evidence.
Yes, thank you.
Would you now take the oath?
May I affirm?
Certainly.
Yes, thank you.
Well, if you say after me the words of the affirmation, I solemnly, sincerely, and truly
I solemnly, sincerely, and truly
declare and affirm
that
I will tell the truth,
I will tell the truth,
the whole truth,
and
nothing but the truth.
and nothing but the truth.
Miss Graham.
Thank you.
Good morning.
Good morning.
You are James Wolffe.
I am.
And what age are you? That wasn't designed to be a trick question.
Sorry, born in December 1962, so 61.
Thank you. You are a barrister, you're a member of faculty, and you're King's Counsel.
I am.
And you were Lord Advocate from June 2016 to June 2021.
I was.
So a period of around 5 years.
Yes.
And in that capacity, you were involved with the investigation into the death of Mr. Sheku Bayo, and you had involvement with the family of Mr. Bayo.
Indeed.
Have you had any opportunity to watch any of the evidence that we've taken?
I'm afraid I haven't. I've had a chance to look briefly at some of the transcripts, but not to actually observe the proceedings.
Well, I only ask because there is a blue folder sitting in front of you on the desk which will contain a hard copy of your statement.
Thank you.
And please feel free to use that or refer to it at any time. Some people do prefer a hard copy. Now, as I go through some of the questions today, there will also be perhaps paragraphs put up on the screen in front of you. If you're happy to simply use those, we'll proceed that way. But at any time, if you wish, please use the hard copy.
Thank you.
And if there's a section in your statement that you would like to refer to, which I've not got on the screen, please let me know and we'll arrange to have that put on.
Thank you.
Equally, occasionally witnesses may recall a document that they would find helpful. And if you let me know, we can look for that over the break if we don't have it on the list for today.
Thank you.
Let's look at the first document, which is SBPI 00438. Now, you were sent a request by the inquiry team called a Rule 8 request with a series of questions which you were asked to consider and reply to.
Yes.
And this is the document we see on the screen that was sent to you in January of this year. And as we move down the page, we'll see that a series of questions appear. That's the covering letter, and then there's the questions start with your role and experience.
Yes.
And in response to that, you prepared a response to that Rule 8 request, which is SBPI 00529. And you see that on the screen? That is your response to the request from the inquiry team.
It is.
I will probably refer to that as your statement, if I may. And this, if we look at the final page, first of all, we'll see it's dated the 14th of April 2024, and it's 66 pages long. And the last paragraph that we see on the screen is 157. It reads, "I believe the facts stated in this witness statement are true. I understand that this statement may form part of the evidence before the inquiry and be published on the inquiry's website." And you understood that to be the case?
I did, yes.
And you signed
I
your
did.
statement? Thank you. We don't have your signature on the screen. And were you doing your best in the statement to give a true and accurate account of your recollections of the events?
I was, and sorry, I should just be clear. I signed it in just by typing my name because of the logistics of returning the statement.
That's fine, thank you. But that was appended as your signature in any event?
Indeed, absolutely.
Thank you. Can we talk about your role for a moment as Lord Advocate? You became Lord Advocate on the 1st of June 2016, and that was, we've heard, shortly prior to the final PERC report being received by Crown Office in relation to Mr. Bio's death.
Yes.
We've heard that that arrived in Crown Office in around August 2016.
Yeah.
You were asked some questions about whether there was some sort of handover from the previous Lord Advocate. And I'd like to begin with that. Could we look at your statement and look at paragraph 22, please? And you explain that you were responsible for the investigation into Mr. Bio's death in terms of your role as Lord Advocate. You say, "I did not receive any briefing or induction on this or any other matter from the previous Lord Advocate, such as a handover on the appointment of a new Lord Advocate from the previous incumbent, would not, I believe, be usual." You then mention the sort of earliest involvement you had. You mention an email from PC Payton's wife. You mention your weekly law officer's briefing, and you mention maybe an oral briefing from senior staff. So you became aware of the investigation to the death of Mr. Bio through those means, through that contact.
As far as I recall, I mean, I think I was probably aware of the case simply from it, the fact that it had been in the media at some point previously. On taking office, those are the, so far as I can now remember, and so far as I've been able to identify from the documents that the inquiry has given me, the introduction that I had to the case.
Thank you. We have an inquiry statement from Frank Mulholland, who was the Lord Advocate prior to you taking
Yes.
on the role. And he has indicated, and we don't need this on the screen, but it is SBPI 00476 124. "I spoke to James Wolffe by telephone and reiterated the importance of this inquiry, including the need to maintain good and regular liaison with the family." Do you remember having a conversation with Frank Mulholland in connection with the family of Mr. Bio?
I'm afraid I have no memory of that, but if he says it happened, then I have no reason to contradict that. I mean, it's fair to say my, as it were, active memory is of the events is limited, and I have relied to quite a large extent on documents. So, yeah, I absolutely wouldn't dispute his evidence.
Thank you. Can we look at some comments you make in your statement? Let's start with 153. Because I think it's fair to say that you've reflected on the issue of a handover, or the lack of a handover, and you had some thoughts that you wish to share with the chair. So let's begin with 153. You say, with hindsight, and with the benefit of the reflection which responding to the inquiry's questions has provoked, it seems to me that it would have been helpful if at the outset I had been given or had proactively asked for a full, clear and detailed written briefing setting out in particular the way that my predecessor had approached the case, identifying any commitments which he had given, any understandings and expectations to which his approach had given rise, and any other relevant considerations, with a view to formulating a strategy for this case going forward. Whilst I, of course, inherited responsibility for many, very many significant cases, and it would likely have been impractical to expect briefing of this sort for all such cases, the previous level of law officer involvement in this case, as well as the substantive considerations which had prompted that law officer involvement, would have justified treating this case differently. I'm interested in your reflections here on what the important factors were and why you think this case should have been treated differently. Was it just simply the law officer involvement?
Well, I suppose it's as I say there, the underlying substantive features of the case which had led to my predecessor's involvement in the case. That included first of all, we have an individual who died in contact with the police. Secondly, there was the issue of race, which was an aspect of this case. And thirdly, there was, as I understood it, and I think I did understand this at the time, that the family had been bad, if I put it this way, not well treated at the outset of events immediately after the death of their loved one. And my understanding was that these were part of the considerations that had led my predecessor to take quite an active role at an early stage. I can't now recall precisely what I knew about that role, and that's part of what's invited this, or led me, as inevitably one reflects back on events and goes through the material, something which could have made a difference to the way the case would have been handled thereafter.
And so you've said a full, clear and detailed written briefing setting out your predecessor's approach would have been assistance to you in developing a strategy, as you say, for the case going forward.
Yes, it would have highlighted this case because, as I say in that paragraph, when I took up the role, of course I inherited responsibility for a large number of cases. I took on responsibility for a wide range of functions. There were many issues, many cases that were clamoring for attention, and I think the reality was that at the outset one is reacting to the material that's brought to one in terms of the focus that one is bringing to any particular issue. And I suppose one of the benefits of our written briefing in the context of the role that I had was that a written briefing would require, in a sense, focus one's attention, require one's attention to a particular case or issue or matter, and would call for a response. And the practical reality of the role was that on any given day I might be receiving a box or more of written briefings on a variety of different issues, all of which would require our response. there would be, had there been such a briefing, it would have called for a response, consideration, and potentially thinking in a more considered way from the outset how matters should be taken forward.
And you indicate that your predecessor's approach, identifying any commitments which he had given. Why do you specifically mention that? Were there issues that arose?
Well, as it became evident, and as well, it's evident from the material I reviewed for the purpose of preparing the statement, that there were my predecessor's involvement with the case had given rise to expectations and certain commitments. There was the issue of an inquiry and how that interacted with any question of criminal prosecution. And there was the question of disclosure of material to Mr. Anwar as the solicitor for the family. And there were also questions of expectation in terms of the role of the incumbent in the office.
Because you've said this type of handover would have been of benefit, looking back now, in the absence of having that full, detailed, written briefing, do you, having reflected on how it was handled at the time, do you have any comments that you'd wish to make?
Well, I suppose I'm looking at it very much from the role that I had in the process, and I think you know, looking at the material as I have to prepare the statement, you know, I was reacting to particular issues as they were brought to my attention. I was dealing with the matters that, as it were, came up to my office, came across my desk, and you know, as I say, I think there was perhaps a missed opportunity to, from the outset, thought about how the case should be managed going forward. I relied very heavily on the experienced people around me.
Thank you. Can we also look at paragraph 154? Such a briefing would have been valuable not simply from the point of view of ensuring a consistency of approach. It could well have prompted a planned approach to communications with Mr. Bayo's family and their solicitor, which would have identified in advance the different levels of meeting and correspondence which might be appropriate, and the point or points at which, or the issues upon which, it would be appropriate for law officers to become personally involved. And you've mentioned consistency there. Was there a concern looking back that you were not dealing with the family in a consistent way?
I think certainly as I've reviewed this that a strong sense that I was approaching it perhaps in a different way from the way that my predecessor had done in relation to the active involvement of myself.
Did you have...
and perhaps a sense, and I can't now say to what extent this was a sense I had at the time or to what extent I'm drawing it from the material, but I suspect I probably had a sense of it at the time. Was you know, that I was approaching the role in a perhaps a slightly different way from the way that my predecessor had done.
Were you aware of issues with communication between the family and yourself? You've talked there about a briefing would have prompted a planned approach to communications.
Yes, I mean, I you know, I think once I was, as it were, cited on the case, I was expecting that there would be a meeting with the family at an appropriate stage. I had a letter from Mr. Anwar inviting such a meeting. I was very happy to have such a meeting. I think I was actually interested in looking at the documents to see there were discussions between Lindsay Miller and Mr. Anwar about when it would be, you know, appropriate for me to have a meeting with the family. And I suppose thereafter, you know, the communications were by way of correspondence with Mr. Anwar. Reflecting back, there might have been a benefit in being more proactive in terms of thinking through, you know, the way in which communication should be handled, and also looking forward to the arrival of the PERC report, the Crown investigation, and, you know, the different roles that people would have in the context of that investigation, and how one might think through communication and family liaison with, you know, with bearing that in mind.
You go on in your statement where we left off, had the Crown done this, so you do make a suggestion, had the Crown done this, it would have enabled a much more substantive initial meeting, perhaps at an earlier stage, directed to finding out before the strategy was finalised what interaction with that process, within the necessary institutional constraints, Mr. Bio's family would find valuable and supportive, and ensuring that arrangements were put in place for consistent liaison at the right level and at the appropriate points in the process. And so, are these your views about how improvements could have been made had that initial briefing been provided?
Indeed, indeed.
And do you think the suggestions you've made here would have got your relationship and the communication with the family on the right footing from the beginning?
Well, I'd like to think so. I mean, it's as I say, I've tried to reflect back on, you know, what I think perhaps was an opportunity missed to, in relation to this case, to you know, take a more considered approach from a much earlier stage. You know, I suspect we may come on to it, but, you know, the first meeting with the family was a very high-level meeting, in a sense, from my perspective, in the sense that my understanding was that it was a meeting to, in effect, introduce me to the family, to add my own commitment to a thorough investigation to that which they'd already received. But on the eve of that meeting, I received a very, very lengthy, very detailed letter from Mr. Anwar raising a whole host of specific issues which clearly couldn't be dealt with within the framework of that meeting. I think there would have been an advantage in perhaps having had a more having considered more fully in advance at an earlier stage just how the Crown should proactively be seeking to find out what would be most supportive to the bereaved family.
And had arrangements been put in place to plan that meeting, perhaps in a more structured manner, in that framework, would you have been willing to address some of these issues that were raised by Mr. Anwar?
Well, there may still be an issue about timing, but I suspect thinking more thinking more positively about things like the the structure of the Crown investigation going forward, perhaps setting up another meeting to address some of the issues that have been raised. There are different, with hindsight, there are no doubt different ways in which one could have been more, taken a more structured approach to it than with hindsight, I think, was taken.
Was there an agenda for that meeting? Was there any sort of structure imposed on that meeting?
So far as I can, I should say my active recollection of the meeting is very limited. I'm afraid, but from the documents, and as far as the documents go, it would be consistent with such recollections I have. The purpose was, in effect, an introduction to Mr. Bayou's family and an opportunity to give them an assurance that I was committed to a thorough investigation of the facts and circumstances in which Mr. Bayou had died. So that was really the purpose of the meeting, as it had, I think, been initially envisaged, and as the briefing that I was provided with advised me that was what was expected and appropriate.
So you envisaged the meeting would be an initial meeting, an introduction to the family. You were new to the role of Lord Advocate and reassurance being given. But the evening before, the family had, through their solicitor, provided a list of issues. So perhaps there was a mismatch between expectations there, between you and the family.
There may have been, and I can't remember how I dealt with the list of issues. I suspect that, but this is not on the basis of any recollection, I suspect I had to be clear that those, I couldn't respond to the detail of the issues that had been raised, and that there would be correspondence subsequently.
Would you have been in a position at that first meeting to respond to detailed questions or issues that were raised? From your own knowledge of the case at that time?
Probably not. I think, again, I'm afraid I can't now reconstruct precisely what I knew at different points of time. But my role, my responsibility as head of the system of prosecution and investigation of deaths was to put in place arrangements that would secure a thorough investigation, first of all with a view to addressing whether or not there should be a criminal prosecution, and secondly to an investigation more broadly into the circumstances if that was required. I approached my role generally as head of our system, where I was responsible for a very large number of cases, many of them significant cases for different reasons, and where I was, my fundamental responsibility was to have the arrangements in place that would secure the investigation that was required in each of these cases, and of course, very particularly in this case.
So was there, from your recollection, was there an approach agreed at that meeting whereby others would go and seek out the information that the family were interested in?
I don't remember whether there was any discussion or agreement at the meeting about how matters would unfold, I'm afraid. Looking at the documentation, it looks to me as though what happened was that as would be entirely usual with correspondence that came into my office, that the letter was passed by my private office to the staff directly involved in the case, in this case Mr. Brown, and he was asked to provide briefing and a draft response. And that was an entirely, normal approach to the way in which correspondence that came into my office would be dealt with.
And we've heard that the head of Cap D at that time was Les Brown. Is
Yes,
that who you're referring to?
That's right.
Can we look at the next paragraph, 155? You mentioned earlier the issue of disclosure, and I think you addressed this here. Such a briefing could well also have prompted proactive consideration of the question of disclosure in light of the previous decisions. I remain of the view that the Crown is entitled to decline to disclose material where such disclosure poses a risk of prejudice to criminal proceedings. But the issue of how to balance that with the understandings or commitments which had already been given in this case would have been grappled with proactively, and the approach which would be taken going forward could have been addressed directly at an initial meeting. I'm interested in this reference here to balancing. To what extent was this a balancing, or would it have been a balancing exercise if you'd had that briefing?
Well, I suppose the starting question is what is the substantive requirement in relation to disclosure, and as it were, what's the margin for questions of judgment. I took the view, and this was an issue which did come, in a sense, to me to take the view on. I took the view that the Article 2 obligations on the Crown in relation to participation of the victim's family, the deceased's family, did not oblige the Crown to disclose, in the context of a criminal investigation, as it were, the ongoing investigative work that at least where such disclosure could pose a risk of prejudice to any possible criminal proceedings. And that was a view I took as a matter of substance. I was made aware, in pretty general terms, I was aware that my predecessor had approved the disclosure of certain materials at an earlier stage. I had to take a decision on the issue as it came across my desk under my incumbency, and to do what I thought was the right thing in my tenure. Having taken that decision, of course, at a later point, a question arose as to whether there were documents that were encompassed within the understanding or commitment that had been given by my predecessor that had not in fact been disclosed at the time, and whether those should now be disclosed. And so, having taken the view I had in relation to the Crown's obligation in relation to its investigation, I then had to consider advice in relation to certain materials that were encompassed, as I understood it, within that earlier understanding. Now, looking at that sequence with the benefit of hindsight, it would have been far better had I, right at the outset, had and indeed asked for clear briefing about what had been committed to, what understanding had been given, and that that issue, and also, I suppose, that faced up with the question of what are we going to do forward, ahead of the question being put on my desk by the letter from Mr. Anwar. And that would have enabled the issue to have been addressed proactively, perhaps at an early stage, whether at an introductory meeting or thereafter. I'm very conscious, with hindsight, while one's imposing on oneself and on a system potentially a level of expectation which may not be right, but I think it is right. That's one of the purposes of an inquiry such as this, is for individuals and institutions to reflect on how they've dealt with certain issues and whether there are things that could have made a difference in terms of improving the way in which things were dealt with.
Thank you. So, in relation to this change from Frank Mulholland to yourself, one Lord Advocate to another, you've talked about previous commitments being made by Frank Mulholland to the family in relation to disclosure. And then you took a decision on disclosure when you were Lord Advocate in relation to whether disclosure should be given primarily to the family.
Yes.
And those were different approaches.
Yes. I should say I'm not sure if I was... first of all, I'm not sure whether what had been given was, and Mr. Brown's minute in October, I think it was October 2017, is a bit equivocal about whether we're talking about a commitment or an understanding. And I'm not sure what I understood about that when I made the decision in, I think it was March or February. I think.
I was going to ask you, when you made your decision in relation to disclosure to the family, were you aware at that time that there had been previous commitments or previous undertakings or previous assurances given to the family about disclosure? I'm
not sure that if I was aware of that. I think I was probably aware that material had been made available to them, and that to that extent I was taking a different approach, but I'm not sure if I was aware that of, in effect, how that previous disclosure should be characterised in terms of any sort of ongoing expectation.
And were you aware of any expectations that the family may have had that disclosure would continue and be ongoing?
I suppose if looking at Mr. Anwar's letter, that perhaps reflects an assumption, perhaps, that there would be further disclosure.
Right. But your view was that there should not be at that stage?
Well, I took the view that I had my overriding responsibility was to, first of all, have an independent, thorough investigation, and in a context where, as I understood it, it was at that stage an investigation into potential criminality, that nothing should be done that could prejudice any future criminal proceedings. It would neither serve the public interest nor the interest of Mr. Bayou's family if things were to be done in that context, and there were to be a prosecution, and there were then to be problems as a result of disclosure. So that was the primary driver. I think I was probably also alive to the consideration that, anything done in one case, in a sense, has to be capable of being generalized. We don't have a system of criminal investigation and prosecution where the Crown discloses its investigation as it's ongoing. And I suspect I had question in my mind as to what looking beyond this case, what the implications would be if one were to accept at the level of principle that that there was an obligation of disclosure, or even that the Crown should disclose, or however one might characterise it, in the context of a Crown investigation of a potential criminal case, bearing in mind that we're thinking about an investigative obligation that applies in Article 2 cases, potentially Article 3 cases. One has to be alive to the, as it were, systemic consequences of any individual decision.
Were you concerned to some extent that allowing disclosure to the family of Mr. Bio, that may open the floodgates to other demands and requests by victims or families for disclosure during the period of a criminal investigation by the Crown?
Well, yes, I wouldn't put it in terms of floodgates. It's more at the level of principle that the Crown, as I viewed it, and maybe it may be one of the issues that this inquiry will want to consider. The Crown has an obligation, responsibility to investigate potential criminality, unexpected and sudden deaths, to investigate those independently in the public interest, and in a context where there is a potential for criminal proceedings, the Crown has to be exceptionally careful not to do anything that could possibly prejudice future criminal proceedings. And at least historically, that's involved a high level of care about what the Crown reveals or discloses while those investigations are ongoing. And as I say, I wouldn't put it in terms of floodgates. It's more in terms of principle, that if one, I suspect, very conscious as head of a system, that if you take a decision in one case, that has to be a decision you would be prepared to take in another case, and that if we were to shift to a system of much more open disclosure of the Crown investigation to victims and the families of deceased persons, that would be a very different system, and one would need to think very hard about the implications and where the boundaries might be. And
we've heard evidence that shortly after you came into the role of Lord Advocate, that the final PERC report was received, and at that stage the Crown then moved into this phase of Crown Precognition, where we'll come on to this, where you're looking at issues of criminality at that stage.
Yeah, that was certainly my understanding.
Yeah, all right. Could we look finally at 156? 156, such a briefing would also perhaps have led me to address at an early stage the fact that a commitment had been given to hold an inquiry, apparently whether or not there were criminal proceedings. That would have provided an opportunity to consider whether, once the PERC report had been received, the Crown should in this case depart from the normal sequential approach, which I have described above, to death investigations, where an issue of criminality has to be addressed, with a view to undertaking the investigations required to provide the foundation for an inquiry, whether a fatal accident inquiry or a public inquiry in parallel with the criminal investigation. So you think that a detailed briefing would have actually allowed you to address the issue of an inquiry, and you mentioned that earlier, that was another issue that was a factor in relation to this period of handover where you took over the role of Lord Advocate, and perhaps expectations existed in the family?
Yes, I mean, I suppose at the when I took over, my first awareness was that the case was with the PERC, and in due course the Crown would receive the PERC report. I then had briefing, and I suspect it may have been my assumption in any event that the Crown was then proceeding to, in effect, a criminal investigation of potential criminality. The normal case, the normal approach in a death case is for issues of criminality to be addressed first and dealt with and disposed of before you look at a potential fatal accident inquiry. And in many death cases, if there's a criminal prosecution, that will exhaust what's required in terms of investigation and public disclosure of the circumstances. So there's a logic to that sequential approach in the ordinary case. I don't think I was aware until very shortly before the meeting with the family that my predecessor had given a commitment in terms which, a public commitment in terms which suggested there would be an inquiry regardless of whether there were criminal proceedings or not. And as I say, this is with the benefit of hindsight, trying to construct, as it were, an alternative approach. Perhaps had I recognized that, it might have raised a question about the way in which, whether that normal sequential approach was the right approach in this case, particularly bearing in mind that one wants to get to whatever the procedures are, that the things should happen with the least duration of time, if I can put it that way.
I think we'll come on to that issue again. So before I move on to that process, you've described your sequential process. Can I ask you a preliminary issue? You may or may not be able to assist us with this. The final PERC report came in on the 10th of August 2016. We've heard evidence that the Crown investigation took place over a period of 2 years. And during that period, when the Crown Precognition was being prepared, you were Lord Advocate for the whole period. A decision was taken at some point that this investigation would be handled by CAPD, not SFIU. We've heard from various witnesses about that. And do you know why that choice was made to allocate the Sheku Bio investigation to CAPD?
I don't. I think my information about the setting up of the team comes from a minute which the inquiry drew my attention to from Stephen McGowan to me, and to the Solicitor General, to law officers, basically advising us of the way in which the Crown proposed to take the matter forward, and dealing with certain other matters.
We've heard from Mr. McGowan on that.
Yeah, but I don't recall being involved in any discussion about which part of the system the case should be allocated to. And I should say I can understand the logic of it sitting with CAPD. That's the part of the Crown Office structure which is specifically looking at allegations of criminality against police officers. The Procurator's Fiscal in that particular part of the system had to deal with questions of excessive force, reasonable use of force, and the like, as part of their day-to-day work. So I can understand the logic. I don't remember why the decision was made.
Thank you. Well, let's move on to the approach that was taken. We've heard, I think you've mentioned, we've heard from John Logue that the normal approach is what would happen, what he would expect to happen in an investigation is they would identify a number of issues which need to be considered. The question of criminality was an immediate and an obvious issue which would need to be explored in the investigation, and in simple terms that was an immediate priority. There may be wider issues which relate to broader learning which could come out of a fatal accident inquiry or an inquiry such as public inquiry. But the priority would be to reach a decision on the criminal aspects as quickly as possible. And he said, I would not expect that that would mean that those individual elements would be isolated off from each other and dealt with one at a time. The investigation, I would expect, would have an understanding of all of them and be trying to make progress on all of them at the same time as perhaps identifying particular priorities. I'm not aware of an investigation where we would take a compartmentalised approach and say, well, we're only going to look at this and we're not going to look at anything else until we've finished looking at this. I think our approach as much as possible is to progress the whole investigation. Do you follow that? Do you
absolutely follow that, and I can well understand. One would hope that that's the way that things might be done. My understanding at the time was that it was normal, as Mr. Lowe observes, to seek to deal with any questions of potential criminality in a death case first, and that decisions in relation to whether or not to have a fatal accident inquiry, and speaking generally, leave it not in this case, whether or not there were issues that had to be dealt with or should be dealt with by a fatal accident inquiry would be often addressed after the question of criminality had been dealt with. And there are good reasons for that usual sequence. I certainly don't in the least dissent from the proposition that one would hope that anyone engaged in an investigation is alive to the range of issues that might be might arise, but my understanding would be that the initial focus would be on, has a crime been committed? Can a prosecution be brought? Should it be brought? And very often there may be cases where that raises a set of focused issues, and there are wider issues about system, about the background and context, which entirely reasonably get left until the issue of criminality has been disposed of. Now, in this case, I think looking back on it, I think this was a case where there would have been good reason to take as broader an approach from an earlier stage as one could, and as I say, with the benefit of hindsight, I can see that.
And you talk about criminality and then broader, wider issues in relation to an FAI. And you've talked about system. Could you help those listening understand the distinction between the issues the Crown are looking at in relation to criminality and the type of broader issues or wider issues that would be covered with an FAI?
Yes, I suppose if one's looking at a criminal prosecution or a possible criminal prosecution question of criminality, one's looking at that within the framework of the criminal law. One is and the admissible evidence that's available. So one has to ask, one's investigating the case, securing the evidence, and then asking oneself, does that evidence disclose that a crime has been committed, that there's an accused person who can be prosecuted, And I suppose ultimately, although in a death case would be unlikely to be a question, you know, where the public interest lies. So it's an investigation that is focused through the lens of the substantive criminal law and the law of criminal evidence. When one comes to fatal accident inquiry, a fatal accident inquiry may examine a much broader range of questions in relation to the circumstances of a death. And the principal purpose of most fatal accident inquiries is to examine whether things have happened from which lessons can be learned in terms of avoiding deaths in similar circumstances in the future. That's not the only circumstance, but that's a very common circumstance for a fatal accident inquiry. And that's not constrained by questions of the substantive criminal law. One's looking in a much more proactive, wide-ranging way at, you know, what the circumstances that led up to a death. Are there things from those circumstances from which we can learn lessons for the future?
So a trial would not be looking at recommendations on how to avoid a death in the future.
No.
Whereas an FEI can clearly look at those aspects.
Absolutely. So the whole lens and focus is completely different. You know, the lens of a criminal trial is this accused person guilty of the offence charged, whereas the fatal accident inquiry is ranging in a much wider way to ask, you know, are there circumstances here which, you know, with the benefit of hindsight, you know, the system as a whole should learn lessons from. So there are, you know, there's quite a different focus, and for better, you know, the normal focus, and as I understood it at the time, and I don't know if it's changed since, would be to seek to dispose of any questions of criminality first, because there are real difficulties in holding a sort of wide-ranging inquiry that could be undertaken, a fatal accident inquiry, if there are individuals with potential criminal charges that haven't been dealt with.
But some aspects will be common to both, regardless of the procedure, such as the circumstances surrounding the death and the cause of death.
Absolutely.
They would be relevant to whatever the outcome.
Absolutely, and that's why in some cases the public interest and indeed possibly the Article 2 obligations, if it's a case to which Article 2 applies, may be exhausted by the criminal process. And you know, in the case of most, I don't know, someone will have the statistics, I would guess, in most criminal cases involving deaths don't result in a subsequent fatal accident inquiry.
So if a criminal trial covered the full circumstances of the death and the full details of the cause of death, that may in itself be sufficient to satisfy the public interest.
Yes.
And so in terms of the Crown Precognition and the work being done by the Crown in a criminal investigation or an investigation into criminality, you would expect there to be a full and detailed investigation and analysis into the circumstances and the cause of death. And that would be of benefit to the Crown regardless of whether there are proceedings directed towards a criminal trial or an FEI, or no proceedings in the future.
Yes, although I think if the precognition is being prepared through the lens of as it were, a criminal investigation, I'm not sure that I'm the person you should ask about what the Crown rules and instructions are in relation to the preparation of precognitions, but it wouldn't surprise me if the precognition was in the context of the, as it were, the criminal investigation stage was focused squarely on questions of potential criminality.
So what would be excluded from a Crown investigation into the circumstances of the death where you're only looking at criminality? What would be excluded from that in terms of the circumstances of the death?
I mean, I suppose I'm I suppose I've been speaking in generalities, so I'm trying to think of examples. I mean, certainly if I go back to the Rose Park inquiry, which is the
nursing home,
a substantial fatal accident inquiry that I conducted for the Crown, that looked into aspects of the legal regime. It was involved multiple deaths in a care home. You know, the fatal accident inquiry looked at aspects of the legal regime for regulating fire safety in care homes, as well as, more specifically, the regime within the particular care home and the more, as it were, the circumstances that were more directly focused on the events. So one could envisage a fatal accident inquiry or indeed a public inquiry looking at a much wider range of the surrounding circumstances than would be appropriate to a criminal investigation that's focused on questions of whether a crime has been committed and whether there are individual accused who can be prosecuted.
Does this come back to what you said a short while ago about systems that may be in place, maybe something more of interest to an FAI rather than a criminal trial?
Generally speaking, of course, one's thinking about health and safety at work. You know, one shouldn't be excluding questions of system, and insofar as questions of system might disclose breaches of health and safety at work or other statutory regulations. But in terms of whether that wider regulatory system was fit for purpose or not, you know, that's not something that would be within the ambit of a criminal investigation.
Thank you.
I've been speaking very generally and in the generality.
Of course. Can I ask you to look at a paragraph in an inquiry statement from Les Brown, please? This is SBPI 00419, paragraph 105. 105. And this relates to what he referred to as an incremental process. I think you've referred to it as a sequential process, but if we could look at that, and it begins with the words "a key element." 105. Sorry, some of the answers went over a number of pages. Here we are. A key element of the incremental strategy approved by the Lord Advocate was to separate out and resolve the issue of potential criminality and to get to a point where Crown Counsel could take a decision in this regard with the necessary confidence, thus permitting the investigation to move forward to other areas in anticipation of an inquiry whose forum had yet to be determined. It had been hoped initially that the necessary further inquiries could be completed relatively quickly. So he describes this as an incremental strategy. And then moving on, the precognition that was requested by Crown Counsel was created for the limited purpose of enabling Crown Counsel to take a decision on potential criminality, but was not intended to be the end of the investigative process by the Crown, particularly in relation to race and implicit bias, and further detailed inquiry would likely have been undertaken had an FAI been instructed. This would, in my opinion, have been highly likely to have required precognition of the police officers involved, where their approach to the incident would have been probed, scrutinised and evaluated. So we can look at the top there. We see, he says, incremental strategy was approved by the Lord Advocate to separate out and resolve the issue of potential criminality. Do you remember approving that strategy for the investigation into Mr. Bile?
The only recollection that I have, and I think it's probably been prompted by the reading the documents, is there was a minute from Stephen McGowan which invited law officer approval of the proposition that was put in that minute. I think from memory that minute envisaged specifically that what was to take place was a criminal investigation. I don't now recall whether it went on to discuss any subsequent or what would happen subsequently. And it may, I don't know whether that's what Mr. Brown is referring to.
And where he refers to this as an incremental strategy, potential criminal proceedings first and later an FEI, is that what we've been talking about as what would have been the normal approach at the time, the linear or
the normal
sequential?
Approach. If I put it this way, reading Mr. McGowan's minute now, I suppose when it was, I read it for the purposes of preparing my statement. It didn't surprise me that the law officers would be asked to approve the arrangements for what was, I think, described in that as a criminal investigation, because I would have assumed at that time that the right approach would normally be to seek to deal with any questions of criminality before moving on to consider whether there were broader issues that would merit an inquiry.
And can we look at the second paragraph of 105? It talks about the Crown Precognition. It was not intended to be the end of the investigative process by the Crown, particularly in relation to race and implicit bias. And a further detailed inquiry would likely have been undertaken had an FEI been instructed. Was it your understanding that issues of race and implicit bias would have been undertaken at a later stage, only if an FEI was instructed?
No, I mean, I would have assumed, I understood that race was an issue that would have to be addressed at all stages, the potential relevance of race. I don't think certainly at that stage, I had no sort of, as it were, preconceived view about what that might involve, but, it was clearly an issue that had to be properly investigated and consideration given to what impact it might have on, first of all, on any question of criminality, and then, potentially more widely.
Fiona Carnan came into the team in Cat D to work on the analysis primarily in about December 2017, and she has explained in evidence it wasn't part of her remit to consider whether there were grounds for an FEI, but her role was restricted to an analysis of evidence in respect of any potential criminality by the police. In relation to this aspect, we've heard evidence from Stephen McGowan, and he talks about being aware of the approach that was taken regarding criminal proceedings and fatal accident inquiries. And he said, we would try and address the issues of criminality first and make a decision on that criminality, which would include, if required, running a trial before we concluded our consideration of the way in which we would present the evidence before an FAI. That was typical. He calls it a linear approach. It was subject to some criticism because of delays that were built in. He has indicated that, and I quote, "I was not of the view that what was being held back was consideration of race. Race, insofar as it was relevant to the question of criminality, was something that would be covered, but there was always going to be a further inquiry, and I think we'd stated probably from an early stage that there had been an FAI." So would you agree with his view that race was not something that was to be held back until a later stage?
Certainly not, and I would have. I mean, I suppose I assumed that the team that was put in place would be addressing all issues that could be relevant to questions of criminality, and you know, including in this case any issues of race.
We've heard from John Logue, who spoke of the challenges in relation to delay that this linear or sequential or incremental approach created or worsened. He said, "One of the challenges we've found in recent years has been that with creating the specialist units, we may find ourselves with an investigation perhaps where more than one team is involved, and therefore there needs to be coordination. We've learned that you may need to progress parallel investigations in two separate teams at the same time, rather than allowing one team to reach a conclusion before the other team then takes over. That simply builds in delay into the process as well. So, for example, you wouldn't want a team looking at a criminal investigation and no one dealing with the broader aspects that I've referred to until that team is finished. You would try to make sure that there was sharing of information and progress on all aspects at the same time." Was that an approach where there was parallel teams perhaps working on the same issue, same matters? Is that an approach that developed during your tenure as Lord Advocate?
I can't now remember whether it did. I mean, it's fair to say that through the course of my tenure, I became quite focused on a number of issues, one of them being delay, and in particular delay in relation to death investigations. The various things were done, but perhaps the most what they called the modernisation project was undertaken in relation to SFRU, which was a pretty significant review of the way that SFRU undertook its work, coupled with and what was really important was securing the resources to enable that changed approach to be put into effect, because what became very evident, and inevitably as one's in a role, one is able to become more proactive in terms of identifying issues that need to be addressed. What became very evident to me was that there were significant resourcing challenges for the Crown in various areas, and in particular in death investigations for a variety of reasons. The work was done to review the work of that unit. The resources were secured. I secured quite significant additional resources over the course of my tenure to do a number of reforms, if I can put it that way. I certainly recall that in the context of the work of SFRU, one of the things that we were keen to do and were putting in place, as I recall it, was, for example, a degree of joining up and consistency of the investigations into deaths in custody. So there was a consistent learning being built in, rather than treating each case as an individual case. Whether part of that involved the, as it were, the cross-departmental working and the parallel working at that time, I'm afraid I can't now remember.
All right. Thank you. We have also heard from John Logue that, and I think he agreed in response to questions from the chair, that even though an incremental approach or a linear or a sequential approach had been taken, you could not consider the question of criminality without considering the question of race. You're nodding, would you agree with that?
Absolutely.
And John Logue said he would have expected CAPD to investigate race as part of their exercise of investigating criminality. Would you agree?
Yes.
And he said you would have to look at race in order to ascertain whether there was any evidence that did have a bearing on criminality relating to race.
Yes.
Would you see that, you've mentioned Article 2, would you see that as part of a thorough investigation by the Crown into the death of Mr. Bio? To consider questions of race?
In the Article 2 context, yes. In the context of the criminal investigation, obviously, insofar as race bore on the on questions of criminality, and there are various ways in which it might do so.
Thank you. And
I suppose I had no particular preconceived view that as to the ways in which race would turn out to be relevant.
And would you have considered whether that process of considering race and investigating race from the outset would have had an impact on the confidence of the family and their engagement with Crown Office?
Well, it seemed to me, race should be being considered and taken into account as relevant at the various stages in the investigation, and the family should have the should be able to have been assured that that was the case.
Thank you. I think you talk about further reflections that you've had in your statement. Could we look at paragraphs 146 and 147, please? Here we are, 146. With hindsight, it is for consideration, given the commitment which had already been given in this case to an inquiry, whether the Crown's investigation might from the outset have encompassed both the question of whether a crime had been committed and wider questions which would fall to be addressed in the context of an FAI. Whilst there is, as I have explained, a logic to the sequential approach which is normally taken, where a decision has already been taken that there will be an inquiry, it may be that this should be departed from. 147, there may be a learning point for Crown Office to consider. Whilst there is, as I have explained, a logic to the usual sequential approach, there may be some cases where Article 2 is engaged and there are potential reasons for holding an FAI, even if there are criminal proceedings, where there would be merit in a criminal investigation and an SFIU investigation running in parallel, potentially within the same team, and this could likely expedite any fatal accident inquiry once questions of criminal responsibility have been addressed. Would you like to expand on your thoughts in this?
Yes, and I'm reassured that Mr. Logue, if I picked up correctly,
Yes.
the quote that you gave me from Mr. Logue's evidence, that it sounds as though that's already the approach being taken. It's actually a reflection that if it's clear that it's likely that there's going to need to be a a process of inquiry that goes beyond criminal proceedings in any particular case, typically by fake license inquiry, but potentially in other ways, that if you, in effect, are dealing with those different aspects, or the sort of narrow question of criminality and any broader questions in parallel, there are a number of advantages. I think when I wrote this, I was thinking particularly about a potential advantage in terms of the overall time scale. But I can see there could be other advantages as well in terms of any possible cross-fertilization between different issues. One would hope there wouldn't be a need for that, but I can see that as well. And it really goes to the point that Mr. Logue, if I picked it up correctly, was making, that there are certain cases where you perhaps want to step back and ask rather than following that's where the normal sequential approach, as I've described it, step back and ask, more broadly, how do we secure the state's obligations under Article 2, if it's a case to which Article 2 applies, in a way that is complete and exhaustive and reaches a conclusion at the earliest practicable point, recognising that these processes take a period of time.
Yes, the reference by Mr. Logue was to the parallel investigations allowing progress to be made and effectively avoiding delay. And he also said you would try to make sure there was a sharing of information and progress on all aspects at the same time. So he talks about that sharing between parallel teams.
Well, I think that the Crown is ahead of the thoughts that I'd had on reviewing this case.
Thank you. And looking now from what you know of the investigation into Mr. Bio's death, you talk about cases where there would not just necessarily be a criminal trial, but there may be wider issues of learning available and a possible FAI. Was the investigation into Mr. Bio's death the type of case that would have benefited from this parallel investigation?
I think it's implicit from the fact I put in the statement that it seems to me that it is. And I think that's probably, in part, this thought was prompted by the fact that a commitment had already been given to an inquiry, I think in terms that was a commitment that applied regardless of whether there was a criminal prosecution or not. And from my understanding of the case, it's not surprising that one would expect this to be a case where there would need to be some wider process of inquiry.
Thank you. I'd like to move on slightly from this discussion about the incremental process and the parallel process and talk about the investigative strategy that was adopted within the CAPD team in relation to progressing the Crown Precognition. Could you give me a moment? I'm conscious of the time. Would that perhaps be...
Yes, we'll have a 20-minute break at this point. Mr. Wolffe, just before we move on, could I pick up on an aspect of the discussion that you were having with Ms. Graham just before the break? And perhaps we could have on the screen paragraph 147 of your statement. Now, Mr. Logue seemed to be contemplating two different departments working in parallel on the same case in the two aspects and sharing information. At paragraph 147, you say that there may be some cases where Article 2 is engaged and there are potential reasons for holding a fatal accident inquiry, even if there are criminal proceedings, where there would be merit in a criminal investigation and a SFIU investigation running in parallel, and you say potentially within the same team, and this would likely expedite a fatal accident inquiry once questions of criminal responsibility have been addressed. And I wanted to pick up on your parenthesis there, potentially within the same team, and I wondered if you thought there might be advantage in the same team working on the two different aspects of the work, as opposed to two different departments.
Yes, I think the key thing, it seems to me, is that when I was thinking about this as an approach, is that you've got prosecutors who are skilled in and thinking about the questions of criminality, and prosecutors with the experience of thinking about the broader issues that are involved in a fatal accident inquiry, who within the, at least in the time that I was Lord Advocate, would be located in the SFIU part of the system, working together. I think the key thing is having the right mix of skill and expertise to cover the range of issues that need to be addressed, and having them working together constructively. Whether that involves or is best achieved by having, as it were, two little teams in separate units working independently, or, as it were, putting them together in a single team, probably has to be resolved on a case-by-case basis. But one wants constructive working between the individuals who are working on the same case, bringing their different expertise to bear. I should say that I can't speak to the sort of, as it were, the micro details of how it would work, but I would imagine that in most cases, these will not be individuals who are necessarily devoting themselves to the single case as the only case they're working on. Sometimes that will be true, but very often I suspect it won't be.
The essential thing is really that they work together rather than operate in separate silos.
Absolutely. That's really what I was trying to communicate by the words in parenthesis.
Thank you very much. Ms. Graham.
Thank you. I would like to move on to look at the approach taken within CAPD. We've heard that Les Brown was the head of that unit, and in terms of the Crown Precognition, Alistair MacLeod and Erin Campbell came in to work on initially to do work to help with preparing the narrative, and then at a later stage Fiona Carnan came in December 2017 to work on the analysis. And at some point, Ashley Edwards, then QC, now KC, who was Assistant Principal Crown Counsel, became the dedicated Advocate Depute to this matter. Now, we've heard evidence from Les Brown that he prepared a minute, which he sent to Alistair MacLeod and others, Lindsay Miller, on the 15th of September 2016, and this looked at the investigative strategy, if I can put it that way. And let's look at a passage from his inquiry statement, SBPI 00419, and this is on pages 47 and 48 of his inquiry statement. Some of the answers span a number of pages. So. And the passage I'm looking for is the one that begins, on receipt of the second PERC report. There we are. On receipt of the second PERC report, the dedicated team at Crown Office agreed an investigative strategy to facilitate the decision-making process in relation to potential criminality. The investigative strategy approved by the Lord Advocate instructed that all eyewitnesses to the restraint process should be precognised by the investigative team. It was agreed that all witnesses should be jointly precognised by 2 investigators to safeguard against any criticism of the precognition technique, following criticism by the family of the deceased of the approach taken by PERC investigators. Was this a strategy that you approved in your role as Lord Advocate?
I think I don't either recall and I haven't seen in the documents ever seeing what one might describe as the investigative strategy. I received the minute from Stephen McGowan, which I think is referred to in paragraph 49 of my statement, which basically invited law officers to agree the various steps identified in that minute with a view to taking the investigation forward. And among those steps was the allocation of Assistant Principal Crown Counsel to the case. I picked up from the documents, and it was a minute that, I can't remember which one, but a minute came to me, so something I would have seen at the time, and is what I would have expected in any event, that she had approved an investigative strategy, or the investigative strategy. I don't myself recall, I have to confess, even ever seeing the investigative strategy.
Let's have the minute on the screen, COPFS 03853A, and I don't believe you were copied into this. You'll see this minute, we've heard evidence from Les Brown about it, 15th September 2016, and it's sent to a number of people, including Alistair MacLeod and Erin Campbell and Ashley Edwards, amongst others. But there's no suggestion this was going to the law officers or to you in particular.
Yes, and there may be some, within Crown Office, when something's approved by Crown Counsel, sometimes it may be taken to have the imprimatur of the Lord Advocate, because one of the features of our system is that every advocate deputy, every Crown Counsel is clothed with the functions and responsibilities of the Lord Advocate, to that extent, approval by Crown Counsel is approval by the Lord Advocate. The individual who holds the office remaining answerable, of course, for whatever's done by Crown Counsel in their name.
And just so that people can follow, the Lord Advocate has a number of deputies who act on your behalf in that role. They're known as advocate deputies. And they take decisions in cases. It wouldn't be possible for the Lord Advocate to prosecute every High Court trial that comes to fruition. So they prosecute on your behalf, argue appeals in the appeal court, take decisions on which cases should be going to trial or a FAI, that type of thing.
Yes, I mean it's a central feature of our system that, in effect, the Lord Advocate is gives by a commission to advocate deputies power to take any decision the Lord Advocate might take, and routinely across the whole range of Crown Office work. advocate deputies or Crown Counsel, as they're often described, take decisions which constitutionally are decisions of the Lord Advocate, but which, in practice are being taken by an individual advocate depute on behalf of the Lord Advocate. Okay. And it would be, and we may come to this, it would be, at least in my experience in the role, it would be absolutely routine for an advocate deputy or Crown Counsel to run a case, to take all the decisions that require to be taken, and for the Lord Advocate or the Solicitor General to have no active direct involvement in the case, and in effect to have that ultimate answerability for everything that's done in their name.
And of that group of advocate deputes, the most senior of those is the principal advocate depute, known as Principal Crown Counsel. And Ashley Edwards, at this time that we're talking about, was the Assistant Principal Crown Counsel.
That's right. She was one of the three, as it were, senior leadership team, if one can use that terminology, within the wider cohort of Crown Counsel.
Thank you. And in fact, prior to becoming Lord Advocate, you have yourself held the role of Advocate Depute and Senior Advocate Depute.
Yes, I spent I think just under 3 years as an advocate depute, and then spent some time prosecuting, conducting the Rose Park fatal accident inquiry again, with technically I think as an advocate depute.
Thank you. Could I ask you to look at COPFS 05119B? You mentioned that a moment ago. If we have that on the playlist, COPFS 05119B. And this is a minute from Stephen McGowan, 29th of August 2016, and it's headed Lord Advocate and Solicitor General. And it's also copied to a number of other people, including the head of CAPD. Is this the minute that you received from Stephen McGowan that you referred to a moment ago?
It is.
And if we can go down the page, it says the purpose of the minute is to update law officers in relation to progress in this case and to propose a timescale for further work. And then it gives a background, and it talks about the work required, the number of witnesses of fact that are required, requirement to consult with 9 experts. We propose to consult with experts. Their answers are reduced to writing. And then subsequently, I think with resources, you talk about 2 senior procurator fiscal deputes with experience of large and complex cases have been allocated under the supervision of the head of CAPD. An assistant principal Crown Counsel has been nominated as the allocated advocate depute in the case, and we propose that we'll keep her up to date at all stages with the ongoing work.
Indeed.
And is that the minute you were referring to
It is.
a moment ago? And just go to the bottom of that. There's also other mention of other matters that are being addressed at that time.
Yes.
Thank you. Could I confirm that after the team is allocated to work within CAPD on the investigation into the death of Mr. Bio, I think, as I understand it from the minute we looked at before this, we can take that minute off the screen. When we were looking at Les Brown's minute that he sent to the team, it became clear that a strategy was agreed whereby Alistair MacLeod and Erin Campbell would precognose key eyewitnesses. And we have other information available to the chair, primarily a briefing note prepared by Alistair MacLeod at a subsequent date in 2020, which summarises the work that was done by Crown Office. And he said that precognition started at the beginning of October 2016, and apart from one, were all completed by the 23rd of November 2016. So between October and November of 2016, the precognitions were taken from the eyewitnesses. And we understand they were taken jointly by Alistair MacLeod and Darren Campbell. I mean, were you involved in any way in that strategy?
Not that I recall. As I say, as I understand it, the investigative strategy was approved by Assistant Principal Crown Counsel, entirely routine for as I understood it, for that to happen. And then it's for the team that's been put together to pursue the investigation.
So at the stage that the team had been allocated, Ashley Edwards had been allocated, who was in charge of the team and the direction of that team? Because we've heard that the members of staff are working within CAPD, and Les Brown is in charge of CAPD. He's the head of that department. And we've heard about Ashley Edwards, who's independent Crown Counsel. So who would you say was in charge of direction?
Well, as I would see it, then the responsibility of Crown Counsel is to provide such direction to the investigation as the team might require. Now, the extent to which Crown Counsel requires to give instructions in the context of an ongoing investigation, certainly in my own experience when I was an advocate depute, would vary. Once an investigative strategy has been agreed, those involved may simply pursue that and implement it without reference needing to refer back to Crown Counsel. Equally, there are cases where Crown Counsel's instruction might be required as the case goes on. And so in terms of providing what one might call strategic direction, or direct, instruction on any particular issues that require to be addressed, that would sit, I would expect, with Crown Counsel. But of course, the procurators fiscal undertaking the investigation itself are, as I certainly understood in this case, very experienced prosecutors themselves. They're lawyers with experience of undertaking investigations. They have their own, as it were, professional autonomy. Because this was being undertaken within CAPD, I certainly understood Les Brown to be, as it were, the leader of the investigative team. And this was also a case where, as I saw it, the senior professional leadership within Crown Office, in the person initially of Stephen McGowan and then also Lindsay Miller, were quite actively engaged with the case. I have to confess, I probably didn't interrogate in my own mind, who was, as it were, had line manager responsibility in that sense for what was going on. But I think from my perspective, the key point that I would have taken from Mr. McGowan's minute, and which I would have sort of carried forward, was that the Crown had put in place a team of experienced procurators fiscal who are, as I say, bring their own professional skill and experience, who were under the direction of Assistant Principal Crown Counsel, who had all the authority that came with the role of Crown Counsel.
Thank you. And as well as precognosing eyewitnesses, the minute that Les Brown prepared and was subsequently discussed, as we understand it, amongst the team, also referred to precognosing ambulance personnel and indicated that other aspects would be looked at: airwaves, broadcasts, transcripts provided by PERC, so that the Crown could be satisfied as to the state of knowledge of the officers attending. I'm interested in the phrase, the state of knowledge of the officers attending. Could you explain to people what that would encompass, briefly?
well, I'm taking it, and I'm afraid I'm reacting to the question on the hoof rather than having any, being able to speak to anything that I might have had at the time. But I take it that one is referring to the information that the officers had available to them when they were when they attended at the scene. Yeah, I mean, I'm assuming that's what would be involved.
I'd like to ask you some questions about the role of an allocated advocate depute or Crown Counsel when they've been allocated to a specific case such as this investigation. Let's look at a statement we've received from Ashley Edwards, SBPI 00445. And if we could look at paragraph 13, please. As you know, I'm not asking any questions about the prosecutorial decision, but I'd like to ask you about her role in the Precognition process. So 13, I was provided with 2 PERC reports and the expert reports that had been instructed by PERC. For your information, that's from Dr. Karch and Dr. Payne James. Okay. I do not recall if I had any further documents at the point of instruction. In September 2016, I met with the case preparation team, at that time Erin Campbell and Alistair MacLeod, 2 Deputy Crown Agents, Lindsay Miller and Stephen McGowan, and the head of Cat D, Les Brown. At that meeting, an outline investigative strategy was agreed. In particular, the civilian witnesses who required to be precognosed were identified. Is that the type of step you would expect to take when the team are planning how they wish to carry out the process of Crown Precognition?
You mean in terms of agreeing an outline investigative strategy?
Yes.
Yes, and again, I'm casting my mind back. My recollection is that at that point it was standard procedure to have an investigative strategy which would be approved by Crown Counsel.
And then I think going back to your own statement, you do address this at paragraph 25 of your inquiry statement, SPPI 00529. Here we are. And you say, at the time of this investigation, only the most significant and complex cases had a specific advocate deputy allocated to them. And at that stage was Mr. Bio's investigation, one of the most significant and complex cases being handled by Crown Office?
It was certainly a significant and complex case. I mean, there were a number of significant and complex cases ongoing, but I'd certainly have regarded this as one of the most significant and complex cases. And just in terms of the allocation of advocate deputies, again, others would be better able to speak to this than me, but there were many fewer advocate deputies then than there are now, and it was a resource that had to be, used effectively, and as I recall it, at any rate. The allocation of advocate deputies to particular cases was the exception rather than the rule, but as I say, others may be better able to speak to that.
And we see that Ashley Edwards was Assistant Principal Crown Counsel, so in a position of some seniority in
Yes.
relation to other advocate deputies. Was that also a reflection of the way that Crown Office viewed this case?
I should say so, yes.
And you say further down the paragraph, I expected the APCC would provide such direction as might be required by the investigation team. I can see from Mr. McGowan's minute that consistent with that expectation, Crown Counsel had agreed the investigative strategy and had instructed further investigations. And was it part of the role of Assistant Principal Crown Counsel, Ashley Edwards, to instruct further investigations that she saw fit at that time?
I would certainly have regarded that as part of the role.
And you then go on to say, I can also see from other documents that there were meetings between APCC and the investigative team in July and November 2017, and there may have been others. So unlike a situation where there maybe is very limited contact between Crown Counsel and the investigative team, it would appear that there were some meetings as well as the investigative strategy being agreed.
Yes, certainly as time went on, and just looking to the documents that I've been able to review for this inquiry, I was made aware that there were the meetings that I've identified there between APCC and the investigative team.
Were you involved in selecting Ashley Edwards for this role of allocated AD, or was that something that perhaps Mr. McGowan was more involved in, or Lindsay Miller?
So far as I can, I have no recollection of being involved. The minute came up to the law officers, in effect, presenting us with the team that was proposed.
Right.
I suspect there would have been discussion presumably with APCC herself, and potentially also with Principal Crown Counsel before. So I suspect that was a decision, as it were, made in putting the team together, and then it was presented to the law officers in the minute we looked at for, first of all to inform us, but also to ensure that law officers were content that the approach that was being taken was acceptable.
Could we look at paragraph 87, please, of your statement? You say the requirement to report a case to Crown Counsel ensures that once the investigation has been completed, the case as a whole is reviewed and assessed by an experienced and independent prosecutor, and that would be Crown Counsel. You talk about Crown Counsel giving directions such like, I'm interested in the final sentence of paragraph 87, which begins, ultimately the purpose of the Precognition. There we are. Ultimately, the purpose of the Precognition is to draw all the material together so that Crown Counsel can review and analyse the evidence as a whole and reach a conclusion. And is that the intention of preparing what we've heard as a document called Crown Precognition, which contains both a narrative and an analysis, to permit Crown Counsel to review and analyse the evidence as a whole and reach a conclusion?
Yes, and of course, lying behind there's the precognition in the narrow sense, which is the narrative and analysis, but in the broader sense includes all the supporting statements, expert reports, and other materials that Crown Counsel may need to consider in order to reach a decision.
And they're all bound up in what's known as the Crown Precognition.
Yes, and that's a very, very long-standing approach to the preparation of cases, which is designed to seek to ensure that cases are prepared to a certain standard and with a measure of consistency, so that ultimately Crown Counsel can reach an informed decision.
You've talked about a situation where there may not be an allocated advocate depute, or there may be, as there was in this case, an allocated advocate depute. Does the approach, the Crown approach to preparation of the Crown Precognition differ if there is an allocated advocate depute? I mean, you've talked about standard consistency. Does it change in format and content if you have an allocated AD compared to no one?
not sure I'm the best person to ask that question. I would expect the basic structure and, in effect, the protocols and guidance in terms of the way the Precognition is put together to be consistent regardless of whether there's an allocated advocate deputy or not least because circumstances may arise where somebody else has to, as it were, pick up a case. But of course, in a case where there's an allocated advocate deputy who may have been, for example, involved in consulting with expert witnesses as the preparation of the case goes along, I can see that in practice the allocated advocate deputy may bring to the Precognition information which is not there on the face of the document.
If the allocated advocate deputy has consulted with experts, would your expectation be that the analysis would simply not include information about that on the assumption that the allocated AD would know all about the experts, or would you still expect the analysis to cover the expert evidence that was available to the Crown?
I'd expect the analysis to cover the expert evidence that's available. I suppose the point I'm making is simply that if counsel has been directly involved, she or he will bring to the reading of the Precognition, the experience they've had of considering the case over time.
All right, thank you. In terms of your expectations of the APCC in relation to Mr. Bio's investigation, you've talked about she determined what further investigations were to be carried out, and would you also have expected her to dictate certain approaches in relation to expert evidence? Identifying experts?
She might well do, in effect, to provide such direction as the investigative team required as the case goes on, and that might include identifying lines of expert evidence that ought to be pursued. It might include lines of or issues that should be raised with a particular expert. But I don't want to impose too heavy an expectation on APCC. This would be a process where she's giving direction to individuals who are themselves very experienced professionals, and just what she would be called on to do would depend on the progress of the investigation and the circumstances.
Right, thank you. Let's look at the information we have about the approach taken by APCC. Could we look at the statement from Ashley Edwards, SBPI 00445? And I'm interested in paragraphs 14 and 15. So this is Ashley Edwards' statement. She says, the initial picture raised the possibility that there was criminality involved. For my part, I approached the matter looking for criminality. As an advocate deputy experienced in criminal advocacy, I looked at all possible adminicals of evidence and how those adminicals could be strengthened, supported, evaluated and corroborated. The investigation team explored and examined every potential source of evidence. A fuller understanding of the circumstances of Mr. Bio's death could only be achieved after the detailed exploration with subsequent legal analysis. And does that description accord with what your expectations would have been at that time?
Absolutely, yes.
And then she goes on to say, I've read my page 3 of my notebook too. I'm not sure if it was just Mr. Nelson's account. This was one of the key eyewitnesses that was being discussed at that time. I also wanted to explore what the witness Ashley Wise could see from the windows In addition, I wanted to explore the number of other witnesses' sightlines. When I wrote the abbreviation RECON, I presume I was thinking about a reconstruction to assess and review all available sightlines. Because of the differing recollections of witnesses and sometimes how those recollections changed over time, I wanted, insofar as possible, to establish fixed reference points as a cross-check to either support or challenge the witness's evidence. And again, does that, I appreciate you might not be fully apprised of this particular circumstances, but does that accord with the type of work you would expect Crown Counsel to be looking at?
Yes, I mean, it doesn't surprise me that someone with the experience of then Assistant Principal Crown Counsel, that she's identifying a line of investigation which will assist in the overall assessment, which she describes in the earlier paragraph.
And did you expect her, as Crown Counsel, to apply an independent perspective to the case as independent Crown Counsel?
Absolutely. I think there are two levels of independence, if I can put it that way. I mean, the Crown institutionally and through all prosecutors acts independently, and one of the things I don't buy the idea, in a sense, that Crown Counsel are uniquely independent in a way that procurators fiscal aren't, for example. It's institutionally the responsibility of every prosecutor to bring to bear an independent and objective view to the cases that they assess and take forward. But Crown Counsel, culturally and often by virtue of their professional background, bring in an added layer of experience, but also a sense of independence from the, as it were, from the day-to-day aspects of the investigation. And it's part of the, as well, the responsibility of all counsel to act independently in the functions they fulfil.
And would you have expected the Crown Precognition, particularly the analysis, to consider adminicals that were relevant to race or racial motivation?
Certainly to the, to the extent that those issues were relevant to the questions of criminality, which were being considered at that stage.
Can you explain the position of what happens if something isn't in the analysis? Do you expect Crown Counsel to look behind the analysis if they've been in that position of allocated AD?
I suppose if there's a gap in the analysis, there are perhaps two courses of action. One would be for Crown Counsel to, in effect, instruct further investigation. But I can imagine a case where Crown Counsel is able to bring to bear his or her own awareness of the case, the access that the access to the primary material that they have, and in effect to be able to address whatever the issue might be. Because one has to remember, one has the narrative and analysis, but lying behind that, as we discussed a moment ago, is the body of primary material, and Crown Counsel can go behind the analysis, and if there's an issue that Crown Counsel wants to think about independently, they have available to them the primary material to do just that.
And would you expect Crown Counsel to be looking at and assessing adminicals of evidence that may have had a bearing on the state of mind of the officers?
I would say so, yes.
We've heard evidence from Mr. McGowan when he spoke to the inquiry. He said this comes down to questions of mens rea, which are again basic concepts in criminal law. So in any case, we don't know what's going on in the mind of the suspect, the potential accused. You get that from everything that goes around about it, whether it's things they've said, whether it's things they've done, and the surrounding circumstances. I don't understand we were asking for anything complex or novel in that respect. And is that your understanding of how the Crown will look into the issue of what's in the mind of someone who's a potential accused by looking at the surrounding circumstances, things they've said, things they've done?
Well, you certainly need to look at, I suppose by nature of it, if you're thinking about issues of mens rea, one is often having to infer from facts and circumstances that are available. I suppose in the context of a case of this sort, you asked me earlier about questions of what were issues of what was known to the officers attending when they were attending the scene could be relevant to an assessment of the way they then responded.
So you don't disagree with Mr. McGowan's comments?
No.
Right? Could we look at paragraph 90 of your inquiry statement? You say, I've been provided with the narrative and analysis sections of the Crown Precognition. The narrative describes, albeit in summary form, the findings of the PERC in relation to both the allegation of racist behaviour on the part of one of the officers and the question of racism within the former Fife Constabulary. I had no involvement in directing or influencing the content of the Crown Precognition. I had no preconception or expectation about the way that the issue of race would be investigated and analysed. This was, in the first instance, for the professional prosecutors charged with preparing the Precognition, subject to any direction or instruction from Crown Counsel. You had no involvement in the preparation of the Crown Precognition.
No.
But I'm interested in this line that you had no preconception or expectation about the way that the issue of race would be investigated and analysed. I'd like to look into that to see what the limits of your expectation were, effectively.
Yes, I suppose what I'm saying there is that I would have expected race to be considered, in the context of the ways in which it could be relevant to the issue. I did not myself. I would not myself have had been setting any limits to what that would be. If I put it that way, it was for the professional prosecutors involved to consider and address that issue in the ways that properly. I certainly would have expected that to be considered at all relevant stages.
Thank you. We have an inquiry statement from Lord Mulholland, and he said race was front and centre from the outset of the investigation. A black man has died in police custody, it was obvious. Do you disagree with that?
Don't disagree with that at all.
Okay.
I'm sorry, I wouldn't want that sentence to be taken as suggesting I wasn't, fully alive to and cognizant of the issue of race. It's more that, in the, as it were, role I had relative to the investigative process. It's not for me to be setting parameters or, at least in the way that I approached it. I had a very experienced team in place, and I was content to trust to their professional judgment, and ultimately I'm answerable for the approach that they took.
And I think a moment ago you said you were not placing any limits on their investigation,
No.
insofar as it related to race or racial motivation,
No.
or any aspect of that. Can we look back at Ashley Edwards' inquiry statement, SPPI 00445, and look at paragraph 16? Here she says, race was looked at as part of the investigation with particular emphasis on the previous disciplinary record of the restraint officers. Race did not really feature in the examination of the actual restraint or the medical evidence, except with regard to the prevalence of the genes associated with sickle cell anemia in the Afro-Caribbean population. Leaving aside the fact that Mr. Bai was not a member of the Afro-Caribbean population, do you have any comments about the statement here from Ms. Edwards that race did not really feature in the examination of the actual restraint? Was that in line with your expectations of how race would be dealt with and considered within the Precognition?
Well, I think, as we said a moment ago, I'm not sure I had any particular expectation. I mean, I do remember that there was an issue about things said by one of the officers that needed to be looked at and considered. As I say, I'm not sure I had any particular expectation or anticipation about where that issue might go.
So on the face of it, you take nothing special from that. You're not concerned about that. That may have just simply been where the investigation took the precognoser.
Yes, I mean, I think that's right.
We've heard evidence from Fiona Carnan. She worked primarily on the analysis, as I've said, and the counter-signatory was Les Brown, the head of CAPD. Fiona Carnan has given evidence that she took a two-stage approach to matters. And if we could perhaps look at her inquiry statement, that may make it easier, SPPI 00379. And if we look at paragraph 45, there we are. And she was asked to what extent was race a factor in her analysis of the actions of the officers. I was concerned with considering whether the actions of any of the officers, either individually or collectively, amounted to criminality. My focus was on the actions of the officers during the period of their engagement with the deceased, and the evidence of how they conducted themselves thereafter. I did not identify criminality on the part of any of the officers involved. Had I identified criminality, it would then have been part of my analysis in respect of criminality to consider whether the conduct was racially aggravated under Section 50A1B of the Criminal Law Consolidation Scotland Act 1995, or whether race was a motivating factor that would amount to an aggravation of the conduct of the accused officers in terms of Section 96(2) of that Act. And then I wonder if we could look at paragraph 38, where she was asked to explain her involvement in gathering and analysing evidence in relation to the extent to which race was a factor in the actions of the police officers. And she said, I was not involved in gathering evidence about race. If my analysis of evidence had established that there was sufficient evidence to support criminal charges against any of the officers, the question of any racial motivation or intention would have been addressed at that stage. Since the analysis of evidence did not identify criminality by any officer, the question of racial aggravation did not arise since no offence had been identified. That description of her approach, how did that fit with your expectations of the Crown's approach to scrutinising evidence for indicators of racial motivation or racial issues?
I suppose the question I'm asking myself reading that is why questions of racial motivation wouldn't be at least potentially relevant to the question of whether or not the evidence supported criminal charges. I'm putting it in that way because, you know, I'd want to think that through, but that's a question, the question that occurs to me reading that.
Let me explain a little bit more about Fiona Carnan's approach, and perhaps we can talk about those reflections at the end. In relation to, she was asked questions about racial tropes. Perhaps we could look at paragraph 8 of her second statement, which is SBPI 462. At the time of your involvement in the investigation, were you aware of any racial tropes being used by any of the response officers in their statements? Are you? And she was asked about that aspect, and her answer in her statement there says, "I have made no reference in my analysis of evidence to the use of racial tropes or negative stereotypes being used by any of the response officers in their statements. However, it is unlikely that I would have done so, since the use of racial tropes is not criminal. Apart from the statements of PC Payton and PC Good, I have not been provided access to all the police statements, so I'm unable to comment on their content as to whether I am now aware of racial tropes within police statements. PC Good and PC Payton both made reference to thinking about the attack on Lee Rigby, and I can see now how such reference could, on one view, be interpreted as a racial trope. On another view, their comments reflect their knowledge of intelligence briefings provided in recent months. As police officers who'd been so briefed, they were alive to the possibility of the incident being terrorist-related. I would not necessarily view their comments as racial tropes. Evidence about negative attitudes of officers to Mr. Bio's race would not be relevant to the analysis unless criminality was identified. From rereading the narrative and analysis, it's my sense that the officers' perception of threat to themselves and the public was based on the reports of Mr. Bio's knife carrying, chasing someone, his physique, and their observations of his demeanour on arrival. Although the report certainly considered the perceptions of the officers, such perceptions were relevant to the question of whether their actions amounted to criminality. PC Good's actions were very limited. Her role was in assisting in securing leg restraints during the restraint of Mr. Bio. Mrs. PC Payton's perception of threat on his approach to the locus in the context of his actions in confronting Mr. Bio and his subsequent role in the restraint was examined in the analysis. No criminality was identified in respect to these officers, or indeed of any officer involved in the incident. And then in evidence, Fiona Carnan said, I have made no reference in my analysis of evidence to the use of racial tropes or negative stereotypes being used by any of the response officers in their statements. It's unlikely I would have done so, since the use of racial tropes is not criminal. Evidence about negative attitudes of officers to Mr. Bio's race would not be relevant to the analysis unless criminality was identified. Do you have any concerns about the approach being taken here?
I think reading that, I mean, I suppose, as I said a moment ago, the question in my mind is whether the points that were being picked up in that part of the statement should have been looked at through the lens of the way it bore on the officer's motivation. And again, I put that in the sense of a question, which no doubt the inquiry will consider, because I'm as we're reacting to that as you put it on the screen in front of me.
So, just to be clear, would you have considered it to be a relevant question for Fiona Carnan to be asking, whether these matters were relevant to the question of the officer's motivation?
Yes, I mean, if questions of motivation are relevant, then one wants to, I suppose, at least ask oneself what evidence one has that could bear on that question.
Regardless of the outcome,
Indeed.
the question should be asked.
Indeed. It's, on the face of it, strikes me as a question that one would want to ask.
Thank you. And then picking up further on the issue of terrorism and Lee Rigby, evidence was available to Fiona Carnan that some officers were concerned they were attending a terrorist incident. Some made reference to an increase in the terrorist threat level to severe. And in her evidence, Fiona Carnan explained she'd fact-checked that, and confirmed that there had indeed been an increase in the threat level to severe. First on the scene were PCs Walker and PC Payton, and statements were available to Fiona Carnan from those officers. PC Walker said, "It did cross my mind that he was doing this to get the police there, bearing in mind we're on a severe threat level for an attack on the police." And Fiona Carnan agreed that the severe threat level referred to by PC Walker referred to a threat level involving a possible terrorist attack. And PC Payton's statement said, "It also ran through my mind that this male could be part of a terrorist plot. I kept thinking about the Lee Rigby boy, the soldier who was killed." Now, in evidence, Fiona Carnan was asked, as part of the process that she went through in her analysis and ensuring Articles 2 and 14 compliance, did you consider why the possibility of terrorism crossed their minds? She said, "I asked the question, although I think it had already been answered why they'd considered terrorism, because they had a briefing. Did you consider whether they would have thought about terrorism if Mr. Bio had been white?" She said no. She was asked, "Did you consider whether they thought about terrorism every time they went to a knife call?" She said no. "Did you consider why Constable Payton thought about Lee Rigby in particular?" She said, "I simply noted his position." She was asked, "You didn't give thought as to why he thought about Lee Rigby?" And she said, "I didn't interpret it as being influenced by his race, no." "Did you consider whether Constable Payton would have been thinking about Lee Rigby if Sheku Bio had been white?" I didn't ask that question. "Did you consider whether there was evidence from which the inference could be drawn that the colour of Mr. Bio's skin was relevant to their concern that the incident was related to terrorism?" And she said, "I did not make that assessment." Now again, listening to that, and I appreciate I'm reading it out to you just now, listening to that evidence from Fiona Carnan, do you have any concerns about that approach being taken, where it would appear the questions and consideration in relation to these aspects was not being given by Fiona Carnan?
Well, I suppose, again, just as it were, reacting to what you're reading to me, one can identify questions that one might like to have seen asked, as you said a moment ago, without sort of prejudging what the answer to those questions would have been, or where they would have gone. I can understand it strikes me that there are questions that material raises.
And in terms of Article 2 and Article 14, would you have expected those questions to be asked as part of an investigation into the death of Mr. Bio?
So, I mean, certainly, ultimately, and also, yeah, well, yeah, I think yes, there are questions that one would want to see asked. Where they would go in terms of an analysis from the point of view of a criminal charge, is I think another matter, and I'm conscious is not within the inquiry's remit.
And I'm not asking you to predict where the answers might have led, but
Yes.
certainly in terms of the questions, that's the type of questions you would have expected to be asked as part of the analysis.
Well, in terms of, well, I suppose that's an interesting question. I mean, questions that one would want to, one might want the team to be asking, whether it would need to appear patently on the face of the analysis. I suppose might depend on where the questions took one.
But where, and it'll be a matter for the chair to interpret the evidence of Fiona
Yes.
Carnan, but where it may be that she did not consider certain questions, is it fair to say that your view is those should have been considered?
I mean, certainly reacting to what you're saying, there are questions I would, one would want to have seen asked. As I say, whether asking the questions would result in, how that would play into the analysis, I think is a different question.
Thank you. We've heard the evidence of Mr. McGowan, and he said that information about was that a terrorist incident that was available at a very early point in the case, and I recall that. My own views is it would have been relevant to ask why it was that they thought it was terrorism, and to consider whether Mr. Bio's race had anything to do with that. And whether or not had Mr. Bio been white, they would have wondered the same thing. That's a relevant question. Do you agree with Mr. McGowan's evidence?
Yes.
We've also heard from Ms. Carnan in relation to Kaylee Good's statement, and I'm conscious of the time. Could I have a moment? Are you happy for me to? I probably won't finish in 5 minutes. Do you wish me to could start and carry on? Yeah.
I think you could probably make a start.
Thank you. Kaylee Good was one of the constables that arrived at Hayfield Road, and she also described in her statement that she gave to PERC about Lee Rigby. And she said, I was also thinking at that point of the Lee Rigby incident in London, mainly due to the fact of the coloured male and the potential terrorist connotations. And so it would appear on the face of it that she made a direct link between the colour of Mr. Bio's skin and the potential terrorist connotations. And Fiona Carnan was asked about this. And she said, she was asked, did her statement, that's Kaylee Good's statement, not perhaps cause you to wonder whether others who also thought about terrorism and Lee Rigby had done so because of the colour of Mr. Bio's skin? And she said, I have to say, no, I didn't. So in this regard, Fiona Carnan was saying she didn't consider this aspect. Again, is that something that causes you any concern, that this was simply not considered?
Well, I mean, going back to Mr. McGowan put it perhaps more succinctly than I did, these are questions that perhaps, questions that one would want to have seen asked and addressed.
We asked Lindsay Miller about this passage yesterday, and she was asked whether Fiona Carnan's response concerned her, and she replied, yes, it is to me indicative of at least unconscious bias on the part of the police officer. Would that be any part of the concerns that you had?
Well, precisely. I mean, the whole the nature of the, as you put it, tropes is that they feed into unconscious bias.
And Lindsay Miller was also asked whether this could also be indicative of unconscious bias on the part of Miss Carnan. And she said, I think I would have to say potentially yes. Have you any concerns about that?
Well, I can't disagree with Miss Miller.
Miss Carnan was asked in evidence if she'd considered whether the link was being made by Miss Good was reasonable or indicative of racial stereotyping. She was asked the link made between the colour of Mr. Bayo's skin and the potential terrorist connotations. Did you consider whether the link she made was reasonable or whether it might have been indicative of racial stereotyping? And Miss Carnan's answer was, I considered it was not unreasonable given the briefings. Was it indicative of racial stereotyping? Possibly. She was then asked, are you saying that now, with the benefit of time to reflect, did you think that at the time? And she said, I don't think I thought it at the time. And then she was asked, even though she said in terms that she had made a link between the colour of his skin and terrorism, she said yes. And she was asked, at the time you didn't think of that as racial stereotyping. With the benefit of hindsight and reflection, your evidence today is that it could be indicative of racial stereotyping. She said yes. And she was asked if it had occurred to you at the time or if you had thought that way about it at the time. Is it something that you might have included in the analysis? And her answer was, it's possible, yes. And Lindsay Miller gave evidence about this passage of evidence yesterday. And she said, I think that is something that should have been included in the analysis. And she's obviously reflected that with the benefit of hindsight. I don't think necessarily that would have made any difference in relation to the consideration of criminality, but it is something that should have been within that document for the consideration of Crown Counsel. Would you agree with Lindsay Miller in relation to that?
Yes, I don't think I wouldn't disagree with that.
Then there was further questions asked of Fiona Carnan in relation to the use of language in the officers' statements, and I'd like to move on to that. But
We'll stop now for lunch and sit at 2 o'clock.